The gentleman is recognized.
Thank you. Mr. Speaker, I oppose the Esposito amendment as its central focus is advocacy for the Law Enforcement Officers' Bill of Rights, a controversial measure pushed by police unions and adopted by many states in response to demands for greater accountability and transparency following many high-profile incidents of police abuse and misconduct. While seemingly benign, the impact of a Bill of Rights for law enforcement officers can be profound. For decades, this type of legislation has been one of the greatest obstacles to police accountability, hindering investigations and shielding misconduct from public scrutiny, a likely explanation for why less than half of all states have adopted one. In Maryland, the first state to adopt and the first state to repeal an officer's Bill of Rights, the statute was also often cited as the reason for Baltimore's long history of police misconduct. In many instances, the statutes offer protections and procedural privileges to law enforcement officers facing accusations of wrongdoing or disciplinary action far beyond those accorded to other government employees or to the average citizen, the average civilian accused of criminal behavior. For instance, some states provide officers involved in an incident a cooling-off period of 24 hours or so before they must cooperate with internal investigators. During this cooling-off period, an officer and his or her attorney may have access to evidence collected during the investigation before the officer is interviewed. And through these statutes, officers are shielded from the very interview tactics that they use on civilians, such as lengthy interrogations or the use of aggressive or threatening questioning or promises or rewards to induce cooperation, both of which this amendment suggests should be avoided to ensure the fair administration of justice when investigating officer misconduct, and only officer misconduct. These laws can allow officers accused of wrongdoing to remain on duty for prolonged periods of time while investigations are conducted, as well as limit the types of disciplinary actions that can be taken against officers accused of wrongdoing. They also often limit the authority of civilian review boards and make it difficult for the public to access information about officers' misconduct in disciplinary proceedings, and ultimately for civilians to hold officers accountable for their actions. These concerns have led to calls across the country to repeal or reform existing law enforcement officers' bills of rights to ensure more transparency, accountability, and fairness in the disciplinary process. When mayors and police chiefs have attempted to reform their troubled police departments, it has been their state's officers' bills of rights that have stood in the way. While this amendment might be well-intentioned, it encourages states to adopt a Bill of Rights for local law enforcement personnel without offering any guidance so that we might not further perpetuate the already problematic nature of these measures, which I have just outlined. Lastly, I note that just as the text of H-Con Res. 40 celebrates local law enforcement while ignoring thousands of federal, state, and tribal law enforcement officers, so too does this amendment. It is for these reasons that I must oppose this amendment. I reserve.
Gentleman reserves. Gentleman from New York is recognized.
Well, thank you. Mr. Nadler, the correct pronunciation of my last name is D'Esposito. Thank you.